But what I find perplexing about this statute is that I would have thought that this statute would have required changed circumstances. More even than personal circumstances, that it would have required changed circumstances, that's the reason for reducing a sentence. Why doesn't the statute say that? And is that what you're suggesting the statute really is all about?
I do think it is for changed circumstances, Your Honor. I think if you look at the legislative history, that's what Congress was anticipating. I think that's why the BOP filed these motions to begin with and continues to have a gatekeeper role today. I think we see that in 3582D, which are the notification requirements for the BOP, which require notifications in cases of terminal illness, which is actually kind of the canonical example that Congress was thinking of. You can look at the original Senate report for the Sentencing Reform Act at pages 55, 121, and 173, if you want some evidence of that. And I think we find, and the other notification circumstance would be when someone is too medically or mentally infirm to file.
I mean, there might be changed circumstances that are not personal in nature, that are in fact legal in nature, and so that there would be a divide between your personal circumstances line and the changed circumstances line. And the example I'll give you is, suppose the statutory construction, the way the courts interpret a given statute, have changed since the initial sentencing, such that somebody was sentenced to, let's say, a long sentence, and then the courts say no. If he were coming up today, actually he wouldn't be found guilty at all. What do you do with that? Is that the kind of thing that can be taken into account under this statute?
No, Your Honor. It's not the kind of thing that can be taken into account, because that's something that's otherwise addressed in the legal system. And the court had a case about this a few years ago. It was Jones against Hendricks. And in Jones against Hendricks, the question was whether someone who had, or we didn't think he actually had a valid claim, but who had a claim that there was a statutory error in his conviction, but he'd already raised it once on 2255, could get relief under 2255. And what the court said in Jones was no, because Congress specifically thought about when someone in that situation should be able to get relief, and it allowed relief on a second or successive only for constitutional claims, not for statutory claims. Now, on their view—
Yes, so that's right. You couldn't do this by way of a 2255 motion. Gosh, it does seem as though there a safety valve would be appropriate, given that somebody is serving a lengthy sentence for something that is not a crime at all. And if we're sort of thinking of this statute as a changed circumstances statute, not as a kind of general do-over for all your claims that you could have brought way back when, but as a changed circumstances statute, that would seem to me to be potentially appropriate.
Well, Your Honor, if Congress wants to allow a remedial mechanism for that, it would be free to do so. It could add and points the Department has either proposed or at least considered proposing a new 2255H3 that would allow that. It is the kind of claim you might be able to bring on a first 2255, and it would be, provided it were brought in time. And Congress can change the limitations on 2255 that it has. But it's drawn a line between finality and error correction, and I don't think it meant for Section 3582C1A1 to be kind of a loophole for whatever—
I'm sorry.
I'm sorry, for whatever it had limitations it had imposed. Sorry, just